If we could call this workshop, this meeting to order, and Commissioner Wesley Davis will do the invocation, and then if you'll join me for the pledge.
Our Heavenly Father, we thank you for the opportunity that we have to come before you today and conduct the public's business and have a workshop on charter form of government. May we use your wisdom and your guidance in this meeting. In your name we pray. Amen.
Amen. Join me in the pledge, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I would like to introduce Virginia Delago, and Virginia is the General Counsel for the Florida Association of Counties, and she's come down from Tallahassee to give us a lot of basic information on what we can and can't do and what's available in charter government. And and then after her presentation, we'll accept questions about any questions any of you may have. And I'd also like to thank all of you for taking the time this afternoon to come here and be a part of this workshop, and we look forward to your input. Thank you. Ginger, it's all yours.
Thank you, Mr. Chairman. Commissioners, good afternoon. And on behalf of the Florida Association of Counties, I'd like to say hello to you from Tallahassee this afternoon. You have in your agenda packet the handout form of the PowerPoint presentation that I'd like to go through with you for a few minutes before we get into the questions. You also have a series of spreadsheets that are also available on our website, which is www.fl-counties.com. This is a series of informational graphs and charts of all of the charter counties currently in the state of Florida, and covering about 30 or 40 different topics, and how county by county the different topics are actually dealt with in those particular charter counties. So we're not going to go through these in detail today. These are for you to be able to have, and then for citizens of your county to know that they can go to our website and get those off of the website as well. So it'll give you a nice reference tool. The other thing that you have is a hard copy of the Florida Constitution, and I want to show you some of the language in here this afternoon dealing with charter counties. One disclaimer: we got the last 20 copies that were actually printed before November, so the amendments that were approved by the voters in November are not in the copy in front of you. However, if you turn to the back cover, it tells you how to get additional copies. These are all free. And so please feel free to get those. But the information and the language that we're going to look at today is all in here. But I just want to let you know that the new amendments are not there. Well, let me take a few minutes just to introduce myself to you, Mr. Chairman, and to the commissioners who may not know me. I am a lawyer. I practiced in private practice for over 10 years in the area of local government law, primarily with finance, tax, and revenue sources. I am not here today as your lawyer, or really as any lawyer. I'm here today as a student of the Constitution and a student primarily of home rule. I had a high school teacher. You know, sometimes the people who are greatly influence your lives come from education. And I had a high school history teacher who taught me two of the greatest lessons. The first lesson was, if you can look it up in a book, don't memorize it, which as a 10th grader was very frustrating for American history, because all I wanted to do was memorize dates and names and places and be able to just spit those back at him, and that's not what he wanted. So I don't memorize the law. I have never attempted to do that. I will tell you if I don't know the answer to a question that you have for me, and I will do my level best to get you either A, to the person who knows the answer, or B, get the information for you. So that's my first disclaimer. And then the second lesson that he taught us in history was always to know, when you're reading history and when you're a student of history and you read a book, what are the biases of the author? I mean, if we take a look, let's just take a current event, the Iraq War. If you're going to read a book that is written by Saddam Hussein, I will guarantee you the story is different than one that would be written by George Bush, but they're covering the same event. So with that, my bias, I am a huge proponent of home rule for local government in the state of Florida. And I mean that for charter counties, for non-charter counties, and for municipalities. I fundamentally believe in the power of home rule and what it can do for local governments and therefore for the citizens in this circumstance for your county. I'm not here today to sell you or not sell you on the charter form of county government. Those are decisions for you all to make with your citizens of Indian River County. But I'm here to give you some information. The Florida Association of Counties, Mr. Chairman, many of you are already familiar with us. We are a not-for-profit, nonpartisan corporation. We have been in existence. We're in our 77th year of operation. We primarily advocate on behalf of Florida's counties in Tallahassee, that is in front of the courts, in front of the legislature, and on your behalf with executive agencies as well. We also have as a very strong mission and a guiding principle of the association is education and providing information and support to county commissioners and to county staff all across the state of Florida. So our goal for today is really information, and to get you some information on charter government and what it can and what it can't do for you. You really in Florida can't start talking about charter government without talking about Florida's counties. We want to take a minute just to introduce you to the counties, talk about home rule powers of counties, charter and non-charter. And one thing to take away from today is that non-charter counties have home rule power in Florida. You don't have to have a charter if you're a county in the state of Florida to have home rule powers. Non-charter counties have them as well, but we'll talk about what the differences between them are. One of the biggest differences and two of the hottest topics that are going on not only in Tallahassee right now but statewide is the power of taxation, what a charter county can do in that area as well. I want to spend a few minutes on that because property tax reform is such a big issue for the state of Florida right now, just to bring some of that to your attention. And then to talk primarily about relationship with others. And what in the world do I mean? I mean how you handle conflict with municipalities if you're a charter county, what your options are in the charter, and how you can govern at the regional level from a charter perspective. So what is a county as opposed to a municipality? Well, if you go to the internet and if you just search even in Google on define county, define municipality, define city, one of the about two or three of the first definitions that even come up generally for a county contain the concept of region and of regional and being a regional subdivision of a state or a geographic area that has more than one municipality within it. If you look also for those definitions, again, just on Google of municipality or city, some of the first ones that come up are district, which says to me something a little bit smaller than a whole region, number one. Number two, this concept of voluntariness. Generally, an involuntary division of the state is something that goes along with the definition of county, whereas with municipality, the concept of it being a corporate entity, which means people have gotten together and decided to create themselves as a municipality. Those concepts are even there in some, even just out on the internet. Well, what does a county do, and what did it do historically? Historically, counties were simply just subdivisions of the state that really served at the pleasure of the state and provided administrative services in a convenient fashion. The counties ran the elections, the counties ran the court system, the counties provided local law enforcement, and things of that nature. But they really didn't get into the area of municipal services very much. We have 67 counties in Florida. 19 of those 67 counties are now charter counties. We have close to 80% of the state's population lives in a charter county now, even though there's only 19 of them. Almost every county that has in excess of 200,000 people in the state of Florida is now a charter county. The counties in Florida, including some of the charter counties, there are some small counties that are charter counties. Columbia County, which is up around Lake City off of either I-10 or I-75, is now a charter county. A couple of years ago, they had a charter review commission that was created. First time out of the box, went on the ballot, and the citizens of Columbia County created themselves to be a charter county. So there are some small counties. It's not just urban areas. But the diversity of the counties in Florida is one of the things that seems to fuel the desire for stronger home rule powers through a charter, meaning that we live in a state that is incredibly diverse. Let me share with you just a quick story. I was at a public hearing in Liberty County, I guess it was about 5 or 6 years ago now. And this was not my agenda item, but there was an agenda item in front of the commission that evening that I was there where the commission was trying to find $10,000. They're in the middle of the budget year, trying to find $10,000 because they needed to replace the engine in the one ambulance that was working. Contrast that financial situation with the fact that there are some counties in the state that have an entire FTE, a full-time person that is in charge of AV for the county commission chambers. So you have that kind of diversity in the state of Florida. Go back to Liberty County. Liberty County, it takes 4 mills of their ad valorem taxes just to fund the statutorily established salaries of their constitutional officers. Just the salaries, 4 mills. A couple of years ago, Palm Beach County, their entire countywide millage was only a little over 4 mills. And so you begin to see the diversity in how can you have a rule, how can you have laws, how can you have procedures that deal with local matters when you have such diversity of local matters that actually face counties in the state. Well, it should come as no surprise that Florida, and you probably already know this, is the 4th largest state in the country now. We have the fastest growing county, we have the fastest growing municipality in the state. We're soon to be the 3rd largest county in the country. And while we have this great diversity, we also have a situation of tremendous growth, and we've actually been experiencing this growth for about 20 or 30 years, and there's no stop on the horizon for that. What that means is that the county governments in Florida, while there are some rural areas like Liberty County still left, the county governments really aren't just governments of rural areas any longer. What's the largest city, Mr. Chairman or Commissioners, in the state of Florida?
Duval.
Jacksonville.
Jacksonville, Duval is the largest city. All right, well, they're consolidated, so maybe they're a little different. What is the largest, let's say, true or pure city? It is actually the 2nd largest city in the state.
Probably Miami.
Miami. Soon followed is Tampa. What's the 8th largest? So we're down to number 3. What's the 8th largest city?
Port St. Lucie.
No. Tallahassee. Now, you've all been to Tallahassee. It's not, I live there, I've lived there for over 13 years now. It's not what I would call a huge metropolitan area, but it is the 8th largest city in the 4th largest state of the country. There are more people who live in the unincorporated areas of Miami-Dade County than live in any municipality in the state. So we take tremendous growth that we have had for the last 30 years. You take the fact that you've got highly urbanized areas. You take all of that and realize that over 50% of the population of the state of Florida lives in an unincorporated area. We're only right at about 51% live in a municipality. Counties are no longer the government just of rural areas is the point. You have almost half of the state citizens looking to county government for the provision now of all sorts of services. You're in the utility business. You're in the public works business. You do recycling. You do solid waste collection and disposal. You're in transportation. You're in stormwater. You're in environmental protection. You're in land use and growth management. You're in all of these areas in addition to all of the traditional areas that we talked about that existed going back to the very beginning of time. So you see where you are. You're no longer just the government of the agricultural areas. That still exists, but that's really not where we are anymore. Where does the authority for you all to act come from? I quickly just want to walk through this so that you understand. You have the Florida Constitution, which you have in front of you, which is the framework for Florida's government and sets out the powers. It also protects the citizens from government. You have the Florida statutes, which contain the general laws. These are the laws passed by the Florida legislature that apply to everyone in the state. You have special acts. They are legislative acts that apply specifically to either a county or a city or the cities and counties in a geographic area. The Florida Administrative Code are the executive rules that govern the executive agency and actually implement and execute many of the laws. Florida case law. I have this one on here because in the area of charter county government, the judiciary has been very instrumental in setting forth the law that governs many of the powers and the authority that charter government has in Florida to execute. I'm going to give you impact fees as an example. It's been a controversial issue in Tallahassee for probably 20 years. Last year was the first year that any general law actually passed the Florida legislature dealing with impact fees. But impact fees have been around for a long, long time in Florida. Where did they come from? They came from cities and counties' home rule power. Cities and counties were sued. It made case law, and all of the laws and all of the rules came from the case law in Florida. There are many other circumstances, particularly as you deal with charter counties, where the Florida case law is very instrumental in defining what the powers are. You have county charters, which are like constitutions at the local level. You have county ordinances that are like local laws, and you have resolutions. This is a map just to show you a picture of where those 19 charter counties are in Florida, and you see a lot in the southeastern portion, the 3 largest counties in the state, some in the southwest. The I-4 corridor is quite heavily populated with charter counties, a little segment in the northeast, and then really whenever you get to Columbia County, sort of that intersection of I-10 and I-75 and you go west, there's only one. I wish I was a political scientist and could tell you why, but that's just the way it is. The panhandle of the state has not taken very much to charter government for their counties. Many have tried and failed. Leon County, in fact, tried many times before one actually made its way to the ballot and then through the voters. All right, we get to home rule. In 1968, there was a constitutional revision commission that was appointed by the governor, the speaker of the House, the president of the Senate. One of the major reforms that came out of the 1968 constitutional revision was home rule, not just for counties, but also for municipalities. I liken this sort of to a parent-child relationship where, and I have 3 children, so I can speak this way. Before 1968, the rules for cities and for counties both went something like this. If I were the state of Florida, you, city or county, live in my house, you abide by my rules, and you do things exactly the way I tell you to do them as long as you live in this house. After 1968, the rules changed. If your child then moved out of the house, that child no longer needs you, the parent, to tell him or her when to go to bed, when to get up, when to go to school, when to study. All of the authority comes from somewhere other than the parent. So what am I talking about? Prior to 1968, in order to have any authority as a city or county in the state of Florida, you needed Tallahassee to tell you how to do it. You needed a law that you could point to, and those books over there in front of your county attorney, the Florida statutes, or you needed a special act that said you can compensate the animal control coordinator, then it would have been the dog catcher, but the dog catcher can be compensated in this way. Or a county of this size can set this compensation level for the dog catcher. And if you wanted to do something a little bit differently in Indian River County, you either had to go to your legislative delegation to get them to file a special act, or you had to go yourself directly to Tallahassee and get a law passed so that you can compensate that person in a different way. Today, those are not the rules. The rules are that you look to Tallahassee only to tell you whether you cannot do something. It is exactly the opposite. You assume you have the authority, whether you're a charter or a non-charter county. I'll show you the language. Either way, you assume that you can do something unless Tallahassee has told you that you cannot. If you look on page 29, actually, of your Constitution, you'll see the particular provisions that relate to charter and non-charter counties in Florida. And the language of a charter county reads something like this, and I want to just quickly contrast it for you to the non-charter counties. It says that a charter county shall have all power of local self-government, not inconsistent with general law. Not inconsistent has been determined by the courts to mean it doesn't conflict with. And let me give you an example. Brevard County, Charlotte County for years, and Hillsborough County to a lesser extent have all tried to cap in their charter how much revenue could be raised in any one year from ad valorem taxes, basically a 3% or a 5%, or they've tried CPI adjustments that the revenue that's generated can't exceed that particular amount. In those circumstances, in Hillsborough County, the Attorney General has told them, no, you can't do that. In Charlotte County, there was a Second District Court of Appeal opinion that said, no, you can't do that. And in Brevard County, there was a District Court of Appeal opinion that said, no, you can't do that. Why? Because the budget process is set out in general law. And even though the charter said the county commission cannot spend more than 3% in ad valorem revenue than it did, or cannot raise more than 3% in ad valorem revenue than it did the year before, that conflicted with general law and the charter provision was invalid. So we look to the general law, we look to special acts when they're approved by the voters, if you're a charter county, to determine if you have the power to do something. And then the last sentence here, the charter shall provide which shall prevail in the event of conflict between county and municipal ordinances. This is the potential for regional government. If you choose to become a charter county, and if the citizens of Indian River County choose to become a charter county, one thing that has to be in the charter is a choice over which ordinances will prevail. Will the county ordinances prevail over municipal ordinances if they conflict with each other? Will the municipal ordinances prevail over the county ordinances when there's conflict? Or do you carve out certain subject matters? There are counties in the state that have carved out things like air pollution, and Alachua County is an example of this. Alachua County has said, we think air pollution is one of those issues that doesn't correspond to jurisdictional boundaries, and we think that we need a regional vision and some regional rules over certain environmental standards as they relate to air pollution. That is one circumstance in the Alachua County Charter where the county ordinances will prevail over the municipal ones. So you can either have county trumps city, city trumps county, or you can carve out particular subject matters and actually deal with those. All right, contrast this language just real quickly to the world that you're operating in today, which is as a non-charter county. Just take even this first phrase. The Constitution says that a non-charter county shall have such power, as opposed to all powers of local self-government, such power. That means it needs to be defined. And then it goes on to say of self-government as is provided by general law. So again, the Florida legislature needs to define and needs to enumerate and needs to list out what powers of self-government that you actually have. And then on further in that paragraph of the Constitution, after the comma, it says, an ordinance in conflict with a municipal ordinance shall not be effective within the municipality to the extent of such conflict. So clearly with a non-charter county, the way the world works is that the city ordinances always trump the county ordinances, unless there's a general law that states otherwise. But a non-charter county needed the legislature to act in order to give it power, which is fundamentally different than a charter county. A charter county, it is automatically assumed directly from the Constitution that you have all powers of local self-government. A non-charter county needed the legislature to intervene and give it powers, and it did. The next couple of slides and the next couple of pages are actually in 1971, the legislature came back and fundamentally revised the powers that were granted to all counties, non-charter and charter, and they included lots of general language to talk about the fact that we're going to list about 35 different things in Chapter 125 that we know you can do, but we're also going to pass language that basically says we're trying to secure for you the broadest exercise of home rule powers that are authorized by the state constitution. What's the point? The point is, at the end of the day, non-charter counties have very similar powers to charter counties, except in a couple of fundamental ways that we'll talk about. So that's why, at its most basic level, the home rule powers tend to be quite equal, and why non-charter counties also have home rule power, because the legislature implemented the section in the Constitution giving you something that is close to being equal. Not exactly, and in some key areas it is different, but close to being equal. Well, what do we call home rule in the counties? There's all kinds of labels like local laboratory, community vision, local choices, solve local problems locally, one size does not fit all, and in the diversity of Florida, certainly that we see that this holds true. Well, again, if you go to the internet, and do you know that there's a place called answers.com? I can't wait to get back and actually play around with this one a little bit more to see what else is out there. But even on the internet here, if you go, and I just Googled home rule in quotes, and it talks about the fact that it's the principle or practice of self-government by localities. And then it talks about some pluses and minuses of home rule. And it says advocates of the expansion of home rule claim that local control makes government more responsive, allows for flexible and innovative approaches to local problems, and relieves state legislatures of parochial issues. And then it talks about detractors emphasize, however, that few issues are strictly local in nature, especially as population of central cities decline and metro areas become more important, which this quote, actually, even that I just found on the internet yesterday, raises the fundamental two purposes of why the Constitutional Revision Commission in 1968 adopted home rule for cities and counties. It was to alleviate the burden on the state legislature from intervening and having to solve local problems. If you go to the legislative library, and they won't let me take it out of the Capitol, but there are volumes of special acts, and if you look at the ones for 1967, which is the year before the CRC met, there are about 3 volumes of special acts that are as thick as any volume of the Florida statutes. If you go back to the year that they convened after these 1971 changes were made, there's 1 volume, and it's about 3/4 of an inch thick. And that just shows you in a very short time period what it meant to the workload of the Florida legislature to not have to intervene and have to solve local problems locally. That also means that you have a burden at the local level to do that. That means to solve the problems that are local, to solve them locally. So the CRC in 1968 wanted to alleviate the Florida legislature's workload on local problems. They also wanted to give you the tools to do that locally, which is that last sentence of the constitutional provision that we read, that when you become a charter county, that you must choose. This is the local dispute resolution sentence. You have to pick which one is going to trump. All right, some of the basic charter and non-charter distinctions. A charter county has the privilege or the burden, whichever way you want to look at it, of choosing the form of government that you will actually operate under. Do you want an appointed administrator? Do you want an elected executive? Do you want that elected executive to be a strong mayor, if you will, or just a leadership head? These are all choices that you have the ability to make as a charter county. You get to establish how you want to govern as well, what your procedures will be, how will the county attorney be hired, who will the county attorney report to, how are you going to hire your county administrator. All of these are choices that are available to you, that are not necessarily available to you as a non-charter county. Those are all spelled out generally around the area of Chapter 125 for you. The power to tax in the unincorporated area is something as a charter county that, depending on the language in the charter, that you have the ability to do. There are certain taxes that municipalities have. One of the most popular ones is the public service utility tax, which is a tax that goes on the utility bill. It can be applied to electricity, to metered natural gas, to liquefied not petroleum, propane, that's the word I'm looking for, the other P word, and a couple of other utilities. It's a revenue source that can then be used for general governmental purposes. A non-charter county cannot impose this particular tax. And if you go to the section of the Florida statutes, it's in somewhere in Chapter 166, which is the statutory section that deals with municipalities. You won't see charter anywhere. But again, the courts have stepped in and said, when you become a charter county in the state of Florida, depending on the language in your charter, you carry with that all powers of a municipality, and that includes some of their taxing power as well. You have the power to alter the functions of the county officers. There are charters in the state that have altered the functions of the tax collector. There are some charters that have actually abolished that office and then brought that office and its functions underneath the Board of County Commissioners. Sometimes with the clerk, there are changes that are made to the clerk's functions. So you have the power to do that. One thing that we have noticed is that when charters first became very popular, I would say there was probably a wave somewhere in the 1970s and in the 80s. At that time, this particular power was one that was very popular and that folks were really looking at. It has become less so popular, I would say, in the last 10 to 15 years, with counties that are moving to a charter form of government to actually alter those functions of the county officers. But it is a power that is there and that exists for a charter county. You have the power, as we've talked about, to have the county ordinances prevail over the municipal ordinances. And then a piece of actual protection for you is that special acts that might be adopted or enacted by the Florida legislature, they then have to be approved by referendum in order to limit your authority as a charter county. So you have some veil of protection as well from a local legislative delegation trying to limit your power in an isolated way. Only if then the citizens of the county approve the special act does it actually limit your power. You have the opportunity as a charter county for governmental reform. You can make very clear distinctions between legislative functions and executive functions. You can choose to make your elections nonpartisan or make them partisan. You can have term limits, all sorts of things in your charter dealing with legislative as well as the executive branches of the county. Again, the constitutional officers, we've talked a little bit about what your options there are. You can abolish the offices completely, you can leave them completely alone, or you can shift just certain functions, or you can do nothing other than, or you can do nothing, or you can do nothing other than make them a charter officer. They're still elected, they're still independently elected, all of their duties and functions remain exactly the same, but they're no longer constitutional officers, they come under the power of the charter. Something else in the area of governmental reform with charters that I think sometimes we forget is that there is an opportunity for greater citizen involvement in a charter form of county government. There are petition initiative processes that exist for either ordinances or charter amendments in almost every charter around the state, and the opportunity at the front end for citizen involvement in becoming a charter county is absolute, because the citizens vote. The citizens voted in 1968 to allow the option of a charter form of county government, and the citizens vote when a county chooses to become a charter government as well. And that means the citizens have the power to say no. So there's the opportunity for greater citizen involvement in moving to a charter form of government all the way through the process. You have the opportunity to give yourself regional, countywide powers, again, in particular areas or just blanketly. And this one obviously deals with the city-county relations. I want to stop for just a second and talk about a couple of cases that have come about in the last several years related to this particular issue in particular. Out of Palm Beach County, there was a case that was finally decided last year dealing with annexation and dealing with voluntary annexation provisions in the charter. Basically, what happened was Palm Beach County had put before the voters approved for voluntary, not involuntary, but voluntary annexation for those procedures to be articulated in the charter. And several of the municipalities in Palm Beach County challenged the charter provision. The court upheld in part the charter provision. What the court said was that the county had the power to set forth the exclusive, so the only way, the exclusive procedure for voluntary annexation in the county, but that the procedure had to be in the charter. What Palm Beach did was gave the Board of County Commissioners the power to adopt an ordinance that would set forth what the procedure was, and that was in the charter. So the charter basically said something like the Board of County Commissioners shall have the authority to adopt an ordinance to set forth the exclusive procedure, blah, blah, blah. But it didn't actually set forth the procedure in the charter. And what the court said was, you have the power to do this in the charter, but it has to be in the charter, giving the Board of County Commissioners the authority to adopt a subsequent ordinance is not going to get you there. It needs to be in the charter. So now, I tell you about that case. It is an appellate decision that was not taken up by the municipalities to the Supreme Court. Pinellas County, however, has something similar and has been challenged by some of the municipalities there. They have lost at the trial court level, and that one is up on appeal in front of the 2nd District Court of Appeal. So just so that you know that while it's a little bit settled in this part of the state, there is a decision that is in front of the 2nd District Court of Appeal on a very similar issue, very similar language in another part of the state, and we don't know what the outcome there will be. So again, the importance of the case law. In Seminole County, again, I think it was either last year or the year before, Seminole County had, again, a charter provision that was adopted by the citizens of the county that carved out certain rural protection areas in the county. And basically what the charter provision said was, we're not going to deal with what the procedure is for voluntary annexation in these areas. That will all flow with state law. So any municipality that wanted to annex these areas in, they just followed state law and everything was fine. But what the charter provision said was, but the comprehensive plan for the county is going to prevail over any conflicting municipal comprehensive plan in these areas. And essentially what the county was trying to do was preserve the rural character of some of these areas of the county by keeping some of the densities a little bit lower. So this charter provision didn't affect the annexation procedures. It dealt with what happened if these geographic areas were annexed and the densities that might have been allowed by that municipality were higher than what the county wanted. The city of Winter Springs challenged the charter provision. They lost that particular case. There was a settlement after the District Court of Appeal issued its opinion, so that one also did not go all the way to the Supreme Court. But those are two cases of recent interest that I thought you should know about. All right, very quickly, in the area of taxation, we talked about Brevard County and Charlotte County and Hillsborough County in the past wanting to place some revenue caps in its charter in the area of ad valorem taxation. This is one of the big areas, the area of taxation, where your power is going to be preempted to the state. And that's really all I want to leave you with here, is just to say that when you're dealing with areas of taxation, with the exception of some of the municipal taxes that you have the ability to levy, you're still primarily going to have to look to the general law, to the Florida statutes, or to any special acts, or to the Florida Constitution whenever you're dealing in these areas. The legislature has the absolute power of preemption when it comes to taxes, even for local ad valorem taxes, whether you're charter, non-charter, city, whatever you are. The thing to keep in mind really is that you do have to ask the question in the area of taxes of what the general law says on this issue. Other additional revenue sources for a charter county, there really aren't many that a charter county can levy that a non-charter county cannot. However, this public service tax I already talked about has been instrumental in some counties, Leon County primarily in the state. They haven't levied it yet in Leon. Leon became a charter county in 2002, but the county commission wanted to preserve to itself the right to be able to do it in the future if it so chose down the line. So getting at this tax was a big deal for Leon County. Generally, it's not a driving force for a county choosing to become a charter county or not. There are some higher rates that you can impose under the communication services tax if you're a charter county versus a non-charter county. There are certain sales taxes. Some of the extra half pennies are available to charter counties that are not available to non-charter counties. And then there's a couple of miscellaneous user fees that are available, but they generally don't amount to very much. So the bottom line here is that there are some additional revenue sources that are available to you as a charter county, but not that many. Hello. There we go. Okay. When you become a charter county, though, your government partners look at you differently. The Florida legislature looks at you a little bit differently. There are some classifications in the Florida statutes that deal with charter counties differently. Charter counties tend to be grouped with municipalities when it comes to intergovernmental issues, and non-charter counties tend to just fall under their powers in Chapter 125. It becomes a convenient classification, and usually if the Florida legislature is looking to give the municipalities as a class some particular power, generally speaking, the charter counties are right there along with them, just as a convenient classification. So there are some things statutorily that are available to charter counties that are not available to non-charter counties. Up until this past year in the legislature, community redevelopment agencies were a very good example in terms of the disproportionate negotiating power that a non-charter county would have with municipalities that might want to create a community redevelopment agency versus a charter county from the very beginning. As you know, with CRAs, if a municipality creates a CRA, then all of the tax increments, so the increase in property value from the investment that is put in that area, goes to the CRA. Well, almost all of them in the state are created by municipalities. Not all of them. There are some that are created by charters, but most of them by municipalities. That means you're losing that increment if you're the county where the CRA happens to be, because it's going to go to the CRA, which is generally run by the municipality. Well, until last year, the negotiating power for a charter county was dramatically different. You, by statute, as a charter county, had a seat at the negotiating table. That was not the case for non-charter counties. It's still not as great. The balance of power there between the charter and non-charter counties and development of CRAs is still not the same with respect to the municipalities, but there was some pieces in the legislation last year that helped mitigate that difference. But just know, again, that as a classification scheme, that charter counties tend to get more privileges, sometimes burdens, but generally more privileges than a non-charter county from the viewpoint of the legislature. And obviously the municipalities they look to the county differently when the county becomes a charter county. Obviously, because of the ability to preempt some initiatives or certain ordinances that a municipality might adopt. But again, if you look at your spreadsheets, not every charter county has chosen to have the county ordinances actually prevail over the municipal ordinances. I think it's still about 50-50, and I think there's only 2 or 3 charter counties that actually have all county ordinances prevail over all municipal ones. Generally speaking, the rule still holds that the municipal ones prevail, but what we are seeing in the last, I would say, 10 years or so is, again, carving out some of these particular subject matters that may not recognize jurisdictional boundaries so much, and then saying in those circumstances the county ones will prevail. Just a couple of closing thoughts. We've talked about regionalism a lot, And the idea that what came out of the 1968 Constitution for charter counties in particular was the ability to provide a regional government. I've already disclosed to you that I have 3 small children. If I were living in Broward County, let me just give you an example of where I think this works. If I were living in Broward County, my husband and I both work, I have 3 small children, it could very well be that my homestead is in one municipality. I take my 2nd grader to another municipality to school. I take my kindergartner to a 3rd municipality. I take my preschooler to a 4th municipality. I go to work in a 5th municipality, and my husband goes to work in the 6th municipality, and we haven't gone more than 5 miles. It may very well be, as a citizen of Broward County, that I would want, at least on some subject matters, to have a uniform set of guiding principles. That is the option that the 1968 Constitution gives to the people of the counties of Florida. The people of the counties of Florida can choose, A, for their county to be a charter county, and then B, for that charter county to have certain regional powers. There's the opportunity for governmental reform. There was an interesting exercise that was actually conducted by, and this is not scientific in any way, and it's just an anecdote to share with you, that was conducted actually by the Florida Association of Counties at an educational seminar, and we split up groups of commissioners, this was about 1.5 years ago, and gave them the exercise if they could create a dream county. And we had all of the governmental reform measures on the table. You could choose whether you wanted partisan or nonpartisan elections. Do you want to have a strong elected executive because you want someone who is directly accountable to the citizens of your county? Do you want to abolish all the constitutional officers and make them all report to the Board of County Commissioner? How far do you want the reform to go? And again, it was just an exercise, and we talked up all these different things and all these different powers, and not a single one of those groups came back and did anything that was, I mean, revolutionary is too strong of a word, but I think there was only one of the 4 or 5 groups that came back that even did anything with any of the constitutional officers. They all left them completely alone. They did do something with elections, and they all had term limits, and that was about as far as they went in even creating their dream county straight out of the box. What's the lesson? I think it's just that sometimes change comes in increments, and that even though these were county commissioners from all across the state, they were still, when you get down to it, trying to take small steps and dealing with particular local issues on a local issue by local issue basis. But the opportunity for reform is great. I think historically what you'd find in Florida is that very same phenomenon playing out, meaning that charter counties come into existence with a couple of reform measures in their initial charter, and then as the citizens grow more accustomed to that form of government, as things begin to take hold, then over time some of those things change and other reform measures come into being. And then I'm available for questions and issues.
Thank you, Ginger. That was very informative. Just a second time. What I'd like to do is set some ground rules. I'd like to have any questions that anyone wants to ask of Ginger. If you come to the podiums and give your name and your address. Yes, Ginger, you had something else?
I do, Mr. Chairman. I know that there was one specific question that folks had, and that was on the ways of creating a charter. By state law, there are 3 ways that a charter can come into existence. Fundamental to all of them is that the citizens vote, but the county commission can adopt an ordinance that goes to the ballot, and then the citizens vote. There can be a special act that comes through the legislature, through your local legislative delegation. Again, that goes to the ballot. And then thirdly, a charter review commission can be created either by resolution of the board or by, I think it's 15%, it's basically a petition process of 15% of the registered voters. I have to go back and look at exactly what the trigger is, but it's 15%, and then a charter review commission gets appointed. If a charter review commission is the way that a charter proposal comes forward, it's about an 18-month process. There are some public hearing requirements requirements, and then what comes out of that process ends up on the ballot. There are 3 of the 19 charter counties were created by special act. By ordinance of the Board of County Commissioners, there are 8. And then by charter review proposal are all of the remaining, which is 7. That leaves Miami-Dade out of the equation because they actually existed by charter even before 1968, so we didn't put them in here. Their charter originally was in the Constitution, so they're, in terms of formation of them as being a charter government, I did not survey them because they really aren't applicable, so that should get you to 18. Just for point of information, the ordinance charters were Hillsborough, Leon, Palm Beach, Alachua, Orange, Osceola, Seminole, and Lee. And of that group, we were able to verify that at least 4 of them, though, had strong citizen review committees. They were not the formal charter review commissions created by statute, but very formal appointed members where drafts of the ordinance, basically drafts of the charter, went back and forth between the citizen review committee and the Board of County Commissioners. But in that circumstance, what comes out of the county commission as an ordinance is what goes on the ballot.
Thank you, Ginger. Again, what I'd like to do is first have any questions of Ginger from the county commissioners, and then open it up to the public for questions from each podium if you come forward at the appropriate time and give your name and address. I'd also like to keep this to questions and not get in a debate over whether we should or we shouldn't, because if at a later date, we can't take any action at this commission meeting because it's a workshop. And so if the commission decides to go forward with this, it would be my intent, and I would assume the other commissioners' intent, to have several workshops to get as much input from not only the municipalities but from the public also. And that would be a time to discuss and debate the pros and cons of what we want to accept. But today's meeting basically is to help us all understand what charter can and can't do. So if we could keep our questions to that, I would appreciate it. And anyone on the commission have any questions of Ginger?
I do, Mr. Chairman. First, again, thank you, Ginger, very much for a very educational presentation. I noticed the majority of the other charter counties elected not to change the status of the constitutional officers. If we were to decide to go that way, is there anything that can be put into the charter to help protect those constitutional officers to remain independent? I guess maybe a more difficult way to petition the charter to change it, or just so the constitutional officers are more protected as elected officials and remain under general Florida law to perform their duties.
Mr. Chairman, I would think that one way to accomplish that is to actually have a provision in the charter that says that the charter is not altering their constitutional status, and then that could only be changed by later amendment of the charter.
Okay.
Thank you.
And then could you, I've read that there's, I guess, charters that are called either a simple or a starter type charter. Could you just briefly explain what that may or may not define?
A starter charter or a simple charter would be exactly as it sounds and just set forth the most basic things that you would need to set forth. I think Columbia is probably a pretty good example of a starter charter. It would not change, the function of it would not change the way you govern right now. And the only thing that really has to be constitutionally in your charter is that you have to choose which of the ordinances will prevail. And a starter charter would have that the municipal ordinances will prevail because that's the status quo for non-charter counties. But basically you would just have a charter that almost mirrors what you're doing today, that then gets approved by the the citizens of the county, and then you begin to move forward from there. The one thing that would be different in terms of how you govern, though, is that you would need to articulate how the charter gets amended, so that you have that process and that procedure going forward. But basically, a starter charter is a mirror of how you're governing today, with just a couple of very minor exceptions of things that need to be in there.
Okay. And then last question, I guess, can you go back from charter to non-charter by amending the charter process at some point down the road? Is that feasible?
It can be repealed.
Okay.
Mr. Chairman.
Yes, Wesley?
With Columbia being the last example, and with Columbia County, and knowing what I know about it, it's relatively a rural area also. What was the legs or the momentum that brought that to fruition?
You know, I don't know. I actually was representing Columbia County at the time in private practice when I was at county commission meetings, and it was actually a citizens group that wanted to have a charter form of government for Columbia. And if my recollection is right, there was a movement to try to limit the powers of the county commission. A charter can set forth recall provisions, for example, for the county commissioners, which actually raises one issue that we've talked in terms of a charter giving a county more power, but there are circumstances in Florida where charter has actually limited the power of the charter government to be less than as a non-charter county. Sarasota County at one time had a provision in its charter that required any tax increase had to be approved by a vote of the citizens of the county. And there was a bond deal that they wanted to do, and the case went all the way up to the Supreme Court, and they actually weren't pledging tax revenue, but because of all the revenue sources put together, it indirectly meant that a tax increase was going to be necessary because they were pledging all the other revenue sources. And the Supreme Court in that circumstance said, you violated your own charter provision here. You said you needed referendum approval for any tax increase, and while you're not directly pledging tax dollars in this circumstance, it's going to cause a tax increase, and you got to go back and do the referendum.
Anything else, Wes?
No, sir.
Any other questions? Sandra?
No, thank
Joe?
you.
As we open the audience up, I'm going to start over on this side, and if you'd bear with me, what I'd like to do is I'd like to give an opportunity to any representatives from the municipalities, whether it be city council, city managers, or whatever, to ask their questions first. And then we'll go back through again and ask the rest of the people, because this is very important that we find a way, if we move forward with this, to work very closely with the municipalities. So I'll start over here on this side. Mayor Cadden.
I'll come down. I was trying to get my question in quickly because it's a housekeeping question for Ginger. Ginger, back 5 slides under city-county relations. You referred to a county, and my fault, I didn't get the name of the county, where they were using the county plan controlled growth. Could you tell me the name of the county?
It was in Seminole County.
Seminole.
Right. In
Thank
just
you.
in the isolated areas, the comp plan.
Right. Thank you, ma'am.
Thank you, Mayor. Anyone from the city, any of the cities represented on this side that would like to be heard? In the middle? Andrea? Jason? Sorry.
Good afternoon, y'all. I guess my question, the chart.
Name and address, Jason.
Jason Unamaker, City Manager, City of Fellsmere. The state statutes are pretty clear on the Charter Commission and the process you follow for that and the implementation schedule. For the special act and the ordinance, could you give general timeframes for implementation?
Mr. Chairman, there aren't any statutorily for that. I think Leon County, and I think I even shared with the county attorney's office, their history in Leon, because it was created by ordinance. It took them, I think it was years, actually, by the time they got to the final draft and through the citizen review committee. And then the timing for the special act is going to be, that's a legislative calendar, because it is an act that actually comes through the legislature. So your notice provisions and their bill filing provisions and all of those rules that regulate the legislature would dictate. But the 18-month, those time periods that exist statutorily for the charter review commissions, they do not apply to the ordinance or to the special act.
So it would basically depend on how fast you could move through and get the information you need and adopt the charter you need. Okay, thank you. Andrea, did you want to speak?
Andrea Coy, City of Sebastian. First, thank you so very, very much for this extraordinarily informative briefing. My question deals with if there's any anecdotal information about CRAs. We in Sebastian have a CRA. In what I'm gleaning from the presentation is that it probably would be up to the charter to outline any restrictions in that. Is it as open? I mean, is there a lot of leeway? Is that up to us to decide? I'm just concerned about anecdotal information from CRA.
Are you talking
Grandfathered CRA. We have an existing
grandfathered? What I was going to ask if it was grandfathered.
Right.
Okay, yeah.
grandfathered CRAs.
And, Mr. Chairman, that's going to be subject to general law, the laws that already exist in terms of grandfathering in. Current CRAs, there are provisions that protect them, generally the charter status and the negotiating flexibility that it would give a charter county is going to exist for new CRAs. There are grandfathering provisions, and that's all controlled by state law.
Okay, and then say that part about the new CRAs, should other ones want to be, municipalities want to look at new districts?
There was legislation that passed last year, and there was legislation that was already on the books that dealt with the powers of a charter county for new CRAs. And it doesn't really have to do with whether you can create them or not create them as a municipality. It deals with the negotiating power and the balance of that power on the front end.
So that's all legislatively in place, then the direction is
That's
already out there.
legislatively in place.
Excellent, thank you very much.
Thank you, Andrew.
Mr. Chairman, while he's
Sal?
coming up.
Yes.
Can you just elaborate about what legislatively is in place with the negotiating powers between the municipality and a charter form of government for a CRA?
Well,
Chapter 163?
whatever is set out in these statute books is considered general law, and whether you're charter or non-charter, you have to be consistent with general law. So you can't, to my understanding, pass a law that is inconsistent with state law.
Right.
No, I'm sorry. Being a charter form of government, you have a different negotiating status, I heard you say, with municipalities. And that is because of state law. The charter is viewed as a municipality.
Right. And back to I don't memorize, so I'd have to look it up, but it's in Chapter 163 exactly there are certain notice provisions that have now been put in place, and there were certain actual agreements or negotiating, what's the right word, folks who had to agree even prior to last year's legislative session, but it's all in Chapter 163.
Is there veto authority, for the lack of a better term? And I'm not trying to get you to, exactly, how much authority does that grant a charter county?
Well, what it's going to boil down to is what the voters approve. I think the idea is that you can negotiate between the county and the municipalities as to which ordinances would prevail within the jurisdiction, but at some point the voters are going to have to sanction whatever is agreed to between the political jurisdiction.
Well, I understand what you're saying about what the voters agree to in the charter, but it sounds like to me that the state statute is providing that authority and that the voters don't decide that in a charter.
I'm not following.
Me neither.
I think what Commissioner Davis is saying is that a charter would not alter the balance of negotiating power or the requirements that are already in Chapter 163, but that as a charter county, that you fall within a different statutory classification and then follow the law as it relates to charter counties.
Right.
Yes.
Is that,
And I just have to go back and look. I don't know. I don't remember off the top. The question really, Mr. County Attorney, is whether Chapter 163 preempts the ability to alter it by general law. And I think the answer is that it's preempted, but I'd have to go look at 163 to see if that can change. But as a charter county, you then fall within the state law and the classification that exists for charter counties.
thank you. Sal?
I forgot. Thanks, Wes.
I'm sorry, I apologize for him.
Sal Neglia, Sebastian. I'd just like to know, how would this becoming a charter government affect the municipalities on the DST, gas tax, tourist tax, franchise fees? Would we receive more, or it doesn't affect it at all?
Doesn't affect it at all.
Very good. Clear
Thank
and
you.
precise. Thank you.
Anyone else in the center section that's with a municipality? How about on this side? Okay, if we'll go back over this side then, and we'll move back across the room. Anybody over here would like to ask a question about this?
Joseph Paladin, 6450 Tropical Isle. A couple of questions. Number one, I noticed that a lot of the charters, the municipality prevails. Their charter prevails. I would think that that was done mainly because there was having to be cooperation between the municipality and the county in order to get it voted in. I wouldn't think that would be voluntary. Is that the reasoning or not?
Well, it's not a legal question, but I would think that, and the way I envision this, if it takes place, is that we will have workshops. And in fact, I would like to have a workshop with the city of Fellsmere, and then I'd like to have a workshop with all the municipalities, you know, when we get back to the commission at one time, like we did with the visioning process, so we can get input from the municipalities and work with them, because I see this as being something for the entire county and not just one segment of the county. So I think all that would be worked out as we go through the process if in fact the commission decides to go that route. I don't know if that answers your question, but.
Yeah, it sort of does, but I'm just wondering, you know, it seemed that it would have to be voluntary in order to have all the municipalities' charters prevail over the county charter.
Well, I don't think it would have to be, and maybe I'm getting into the legal area here, but as I understand it, it doesn't have to be, there'd be cooperation setting the charter, but whatever you would adopt in the charter and that the electorate would vote on would be the law in the charter, whether the municipalities or the county agreed or disagreed would be irrelevant. It would be what the voters wanted and what charter's taken to the public. That's why I think it's important that we have good communication on this.
Mr. Chairman, Joe, it sounded like to me you're asking the question, in most charters, why did the county ordinance be trumped by the city ordinance?
Right.
And it would seem, I mean, just looking at it from most populated areas to the south of us and to the north and all these other areas, probably because the city ordinances that were the city's jurisdiction or limits probably superseded or encroached more and more upon county land, that it was probably easier just to adopt the city ordinances than it was to do the county ordinances.
Well, you know, what I was basically looking at is to stay in our local area. I mean, looking to the north of us in Brevard County, obviously Palm Bay's charter prevails over Brevard County's charter.
I think it's the way their charter's written.
Right.
And you're talking about annexing and so on and so forth.
Right, exactly. So, I mean, I would say that the only way that Brevard County could get their charter passed was to agree to let Palm Bay's charter trump theirs. That's what I was basically suggesting and asking.
Could be too.
I didn't think we were going to debate this thing.
No.
Going to the attorney up there. Excuse me.
Got a couple more. Another thing is that one of the major things we're concerned with in this county is moving the urban service line. Is there any data on how many times the urban service line was moved with the charter being in place and without the charter being in place in the state of Florida?
Mr. Chairman, I don't know the answer to that. Again, it's something that we can find out by surveying, and the only thing we would know is primarily what exists now. I mean, how things have evolved over the last 30 years, and whether somebody had a charter provision 20 years ago that might have done that might be hard to find out. But there's not a good clearinghouse for that kind of information, but we can survey the current charter counties to find out.
I think the only case I'm aware of is in the St. Petersburg, Pinellas area. There was a case where there was a charter requirement that there be a referendum to amend the urban service boundary. It incorporated changes or requirements of general law that couldn't be applied to 5 or fewer parcels of land, but I believe it was validated that they could require a referendum on changes to the urban service boundary if it involved more than 5 parcels of land.
Thanks, Will.
That's the only one I know about.
And one final quick question. On the comp plan changes, would all comp plan changes have to be approved by municipality and the county, or would it matter on how the charter was written? In other words, would the state preempt that?
State law is going to preempt. The municipalities would still have their own comprehensive plans, and the county would still have its own comprehensive plan.
Thank you.
Thank you. Anyone else on this side, on the left? Anyone in the center have any questions?
Couple of questions. One on
Give us your name, please, and address.
Oh, I'm sorry. Fred Mensing, 7580 129th Street, Sebastian, actually living in Indian River County. On the comp plan amendments, would charter government, would large amendments still go to the state?
Yes.
That's a yes, okay. Yes. Secondly, would there be a way under charter government that the charter could define the change in locations of the voting districts for the supervisors, and have it that, like Mr. Davis represents mainly the North County, that he would only be voted on in the district that he represented, and Mr. Wheeler in his district, rather than the at-large elections we have now?
Mr. Chairman, the districting scheme and the number of county commissioners are decisions that a charter can make, and then the people can choose if you wanted to go to 7 members, if you wanted 2 at large, 5 single member. I mean, all of those decisions are decisions that could be made in the charter.
And lastly, with selecting a size of commission, could the, under charter government, we have that the chairman/mayor of the county would be an elected official who would be the non-voting head of the commission for the term of his election, rather than having the power pass between the various commissioners? Yes. Thank you.
Yes.
Let me clear that up, because I want to make sure I understand, because that would be a form of charter that could be adopted. There are different forms of charter that can be adopted. That's just one form. We could have a manager style, so on and so forth. And that would all be up to the electorate also. Anyone else in this section? Yes, sir. Williams?
Take this opportunity, Jim. Several of you have given those, but I wish you'd hand those down to us. I'm John Williams. I live on Smuggler's Cove. If you're familiar with the Brevard charter, ma'am, wouldn't you call that a simple or a starter type charter? It seems to me, in reviewing it, it's extremely its simplicity itself changes nothing except obviously setting up an opportunity for citizen initiatives. My question to you would be, since traditionally one of the main objections to a proposed charter government is concern about the constitutional officers being appointed as versus being continued to be elected, and that was raised here as well today. For instance, that charter of Brevard provides a 5% vote, 5% signature collection as a citizen initiative to get anything changed from the citizen level. If it would it be conceivable to offset some of the red herrings that might be raised on the constitutional officer issue, to have a structured charter that would provide, let's say, 5% citizen initiative, except if a change wanted to be made to the constitutional officers, it would require a 10 or a 15% initiative? You could have 2 separate provisions. You could, okay.
Yeah.
Thank you.
That would be something that would be debated when we go through the workshops.
Right, but I mean, I wanted to see if that was conceivable, if
Yes.
that was doable.
Anyone else? Renee?
Renee Renzi, Waverly Place, Vero Beach. Did I understand you to say that under charter government we could have a non-partisan county commission?
Yes.
Yes, that's a choice that can be made in the charter.
Good. And would the voters be able to set the pay scale for the county commission?
Yes.
Yes.
Good. Thank you.
Mr. Chairman,
Okay, go ahead.
while we're doing this spreadsheet that was distributed to us, I guess today, maybe Kim, if you could make some extra copies, I think this would help a lot of the people, because this spreadsheet actually answers a lot of the questions that are coming up. And if we can make that available, is there someone back? Okay. Yeah, just.
Okay, anyone else in the center? Mayor White?
Good afternoon. Tom White, Victory Boulevard, Vero Beach. My question is that we talked about voter referendum, and I know the county is very interested in height and density in the county. Now, would their voter referendum override this, let's say, a city's charter for their height and density? That would prevail over, like, the city's charter?
Mr. Chairman, it would depend. If the charter chose for height, that if there's a conflict, so it doesn't affect the city's density or any municipality's height restrictions, but only if there then becomes a conflict, meaning that there's an annexation or a new development goes in or something where those two ordinances then actually butt heads against each other, then the charter can choose and then the people vote on that particular choice.
And the county voters would vote on that besides the city voters, correct?
It's countywide.
All right. Then is there any provisions for a dual referendum?
There are provisions by Constitution for dual referendum in certain circumstances.
Okay, specifically for that type of circumstance, would it? The city has a very strict, City of Vero Beach has a very strict density, height and density rule. And we're just afraid that if there's a conflict between the county and the city's charter, that we would still like to see the City of Vero Beach prevail. And that's my concern. And that's why I wanted to ask about dual referendum, and you would consider that. Thank you.
Now, let me make it clear that I agree with your charter on height and density, Tom. Did you want to say something, Peter?
No, I'm good.
Okay, B. And then we'll be back to you in a minute, David.
B. Gardner, Vero Beach. I would like to defer this question to Ginny because of her expertise. And I don't even know if I can get an answer, but what I'm looking for in this process is perceived unintentional consequences. Is there any kind of a list or red flag items that we could be given so that we can perceive some unintentional consequences of going to a charter?
Mr. Chairman, I don't know of such a list, but there are folks, there are law firms and attorneys and consultants that if the county chooses to move in the direction of examining the charter form of government, that can help with a lot of that and have decades of experience, and that's what they do, is help counties and in some circumstances municipalities with charter reform. And so it's probably a good question for those folks who deal with those people and in those circumstances on a day-to-day basis, but I don't have such a list.
And if there is such a person or persons, would that be very difficult to find out who they might be so that as the process begins or starts, we can have that person look over what we're doing?
I think, yeah, there are consulting firms out there, and that'll probably be discussed at the county commission meeting.
Well, that was my question. Thank you.
David, just a minute. I'll be right with you, Mr. Mayor.
Thank you, Mr. Chairman. David Nolte, 900 Royal Palm Place in beautiful Vero Beach, Florida. I'd just like to ask a question of Mrs. DeLegal about the concept of sovereign immunity. I haven't heard anything about that today.
It's not altered by the charter.
If we go to charter government, don't we become a corporation under the state?
You maintain your status as a political, so you already the county already has sovereign immunity. So that
Isn't that something we give up when we do that?
No. You're still immune under sovereign immunity from the state.
Well, that's good to hear, because I've heard that was one of the major problems with it. Thank you.
Thank you, David. Mr. Minner?
Thank you. Al Minner, City of Sebastian, live at 386 Belfast, City Manager. Mayor White brought up a good question. I just kind of wanted to boil this down a little bit more. And that's when we would potentially get into conflicts on whose charter superseding on planning and zoning, land development type regulations or what have you, or CRA issues. And those issues would only come up after an annexation. So the way the map is now and the way the jurisdictional boundaries are now, that stays. And county rule stays in the county and city rule stay in the city, but we wouldn't get into those conflicts unless the city would annex out after the immediate date of the formation of the charter.
That would be by intent, but that's a good question because I don't know the answer to it.
That my experience back when I was in Fort Meade in Polk County, that's how that home rule existed. Was everybody's rules were the same, but once you annexed out, then everybody got to fighting.
I believe it would be just like Seminole County, and their charter reads that municipal ordinances will prevail over county ordinances except for those lands that fall into what they call the rural area, which would basically be lands outside the urban service area. So, for Mayor White's concern, municipal ordinances would still apply unless you go outside the current urban service line under the Seminole County Charter.
Could you answer that, please?
Yeah.
Mr. Chairman, again, this is going to sound like a broken record, but it depends on the choices that are in the charter. And one of the issues that has been raised that we did not talk about through some of the last questions are that there is a provision in the Constitution that requires dual referenda whenever functions of government are going to be transferred from one to another. So if there were to be a usurpation, if you will, of an entire municipal function in the county government, then the Constitution would require a referendum of the municipalities as well as a countywide referendum. It's intended to protect. This is some of the conflict in the Constitution between some of the provisions in 1968 that deal with county home rule, but then there is this provision that also helps to protect some of the municipal functions and requires a dual referendum. So only in certain circumstances when those functions get triggered. Now, obviously, the next question is going to be, well, what are those list of functions and services? And my answer is, it's not completely clear. There are cases that are still going on that litigate what exactly are the functions and services that rise to the level of requiring the dual referenda. I will tell you that in the Seminole County case, that issue was raised, and the court in that circumstance said that with the rural service area and the comp plan conflict and the choice that was made in the charter, that was a land use regulation and it was a regulatory matter that was not subject to the dual referendum requirement of the Constitution. That's not going to be the case in every circumstance. So every land use choice that is made is going to require, my advice to you would be an independent analysis of whether, okay, have we crossed the line and does Does this one require a dual referenda, or is this a choice that simply can be made in the charter? And there isn't a list that exists, but again, my recommendation is that as those issues come up, if the county is going in that direction, that you need to do an independent analysis of each of those choices and determine whether a dual referendum would be required.
Can I ask a clarification on that answer? So basically, that leaves it open to how the charter is established in the county. The charter in the county could be set up to where on land development codes, their issues supersede existing municipal land development codes, or it could set up to where we draw boundaries and we only deal with things after an annexation. It just depends how it's set up.
Yes, but depending on how it's set up, it might trigger this other provision of the Constitution that actually protects the municipalities and would require the dual referenda. So, again, my advice is you need to take it issue by issue, particularly when you're dealing with an area, in this particular area. If you're going to start carving out particular subject matters, is that you need to look at each one individually to determine whether a dual referendum is required, because it rises to the level of actually taking an entire function from a municipality. Those are the questions that have to be asked. I don't know what the answers are, and it's going to depend on the circumstances.
Thank you.
Thank you. Is there anyone else that would like to ask a question? If not, I thank all of your participation, particularly Ginger. I thank you for taking the time to come down. We appreciate it. Thank you. Thank you.
You got here just in time.